Good evening. This is John Milburn for Laws 12066 Land Law. We're into week 3, and this week the reading relates to the torrent system of land. We're still within the bounds of indefeasibility. This week we're talking about the exceptions to the rules relating to indefeasibility. So this week we consider a number of key issues. We're dealing with the Land Title Act primarily, and of course I'm referring to the Land Title Act in Queensland. And great to see everyone joining us for the live session, so thank you. So indefeasibility is a concept that we talked about in Foundations of Law. We dealt with it last week, and you'll be familiar with the fact that it now is encompassed in statute in Queensland in the Land Title Act. So that's the section, that is the legislation that is the central theme of tonight's discussions. There are exceptions provided for in the Land Title Act, that is exceptions to indefeasibility. There are powers provided to the Registrar to correct errors in certain circumstances within the title if there are issues. There are other exceptions contained within legislation. Occasionally, you'll find overriding provisions in other statutes, and the courts have an overriding jurisdiction. So, time permitting, I'd like to deal in a little more detail with a particular case, which demonstrates the way in which the courts do have this overriding jurisdiction to deal with issues to deal with relating to indefeasibility and registration issues. So just a quick recap in terms of indefeasibility. What we've learned so far is that Torrens title, as reflected in the Land Title Act, provides for the indefeasibility of the title of a registered proprietor. And we know that a registered proprietor means more than someone who is the owner of the property. So other people, other than owners, have an interest as registered proprietor. If we go back to Gibbs and Messer, Lord Watson said that in trying to describe what is meant by indefeasibility, that everyone who purchases bona fide and for value from a registered proprietor and enters his deed of transfer or mortgage on the register shall thereby acquire indefeasible right, notwithstanding the infirmity of his author's title. Now that's a quote at page 254. Without meaning to be disrespectful, in some way, I'm going to pick that quote apart tonight because I think there are a few errors in it. Now, I need to be very careful. Who am I to say that Lord Watson is incorrect? I'll preface that by saying it's correct, but I think in light of modern practice and terminology, we can modify it. Perhaps that's a safer, more respectful and more accurate way of saying it. So some of the things that His Honour said in that quote was, everyone who purchases bona fide from value, for value, is entitled to effectively indefeasibility. Does anyone have a problem with that comment? Purchases for value. In your reading so far, is acquiring for value a prerequisite to acquiring indefeasibility or the benefits of indefeasibility? Any thoughts? What about gifts? Exactly. That's part of what I thought of when I read that quote. What about an inheritance? Yes, thank you. So Monique and Karen have identified those, and a voluntary transfer. Yes, so I think that's where we need to, if you like, consider what His Honour said, but in a more modern context. And I think you're right. I think it goes indefeasibility and the protections afforded to a registered proprietor do not rely upon that proprietor having purchased for value. The next thing is enters his deed of transfer or mortgage. Well, I think it goes beyond transfer or mortgage, doesn't it? For example, a person who is a registered proprietor through lease has the benefits of indefeasibility. So it's not limited to a transferee or a mortgagee on the title. Gains the indefeasibility right. And of course, note the way that people spoke in 1891. It's a little different now. We don't say shall thereby acquire. I do like it. It's got a nice ring to it, but we just don't do that anymore. And I like this, notwithstanding the infirmity of his author's title. That is really lovely, but it's more, now again, respectfully, that's more for a novel. That's not the way we speak now in law. And of course, can anyone else pick up on a glaring error in the terminology used by His Honour, which was perfectly that's it. That's what I was after. So the difficulty now for drafting material is that you need to steer clear of that, but not use too many words, and preferably not use his or her. So a technique that I use is I somehow work there into the title. So a registered proprietor may protect their interest by registration, for example. So it's a way of doing it. It's not necessarily the best way, but I'm sure that we're all working on our methodology for ensuring that we are gender neutral in terms of our terminology. But anyway, that's the way we spoke in 1891. However, the message from what His Honour was saying is clear, that this is, through indefeasibility, a title by registration rather than a title of registration. And that reflects the comments of Chief Justice Barwick in Breskvar against Wall. So the aim of Torrens title is pretty simple. It is to provide certainty and for the register to speak for itself. And the aim is to simplify the process where someone who wishes to acquire an interest can rely on the register, what's contained in the register, and they need not look behind the register in order to gain the benefits of indefeasible title. So,
sorry.
Yes, Tamara.
Might sound like a bit of a stupid question, but so with the Torrens system, it's a register, as we know. But back in 18, whenever it was, when Mr. Torrens developed it, well, they didn't have online and internet and that sort of stuff. So, in what way was it different to the old system? Does that make sense? Because if it's still a heap of papers and sifting through and whatever, well, that's kind of the same thing. Yeah.
Oh, Tamara, I can answer that question with some degree of authority because, like Mr. Torrens, when he created the system, when I started to practice law, we didn't have the internet or any online materials. So those of you that are working with me in conveyancing may have heard something about this, but and it is a great question. Thank you, Tamara. When I started, we didn't have, well, actually, facsimile machines was we couldn't believe it when a fax machine came in. We thought it was magic. Honestly, I couldn't get my head around it. So, and telephones, of course, were not push button; they were dial up. Hands to the. So that'll paint the picture of what it was like when I started. And when I started in order to do a title search, it meant physically walking to the titles office, asking for the volume, and the volumes were books containing 150 folios. And so someone behind the counter would physically go to collect the volume that I wanted, place it on the desk, and I would then inspect weren't allowed to take it away. I'd inspect by going to the folio, which was one of the 150 pages, and I would then write notes. You could ask for a copy of that, and that was, if you like, the original title deed, which meant that when people had their certificate of title, it wasn't actually the original, it was what we called a duplicate original. Anyway, the system worked on the basis that whoever was named on the title, which should also be reflected in the duplicate title, which was in the possession of someone in the public, was evidence of indefeasibility. So that was the register. So the actual volumes and folios in those books that were on all those shelves in the titles office, and I'm talking in the late 70s, early 80s, did amount to the register. So we didn't have electronic means, but By 1994, of course, with the Land Titles Act, we were able to modernise this to reflect the existence of the online presence, which is reflected in what we see now. I hope that provides some answer, Tamara.
So it basically just centralised a paper trail. So rather than having to go, sort of left, right, here, there, up and down, you just go to some office and they just so happen to have all the documents that you need or whatever, and that was that. So that was the original torrent system, and of course now it's all electronic.
That's it, yes.
Okay.
So the Registrar of Titles, the Registrar used to maintain a paper system, and originally people would write the name of the owners. That became modernised and we started to type it. But yes, it was all paper-based and now it's electronically based. So I'm glad you asked that. Thank you. All right. But we know that indefeasibility and indefeasible title is reflected in the Land Title Act. Have a look at section 38, which provides that the indefeasible title for a lot is the current particulars in the freehold land register. Now that hasn't changed that concept hasn't changed since Torrens invented it. It's just that the freehold land title, the freehold land register looks different now to what it did in 1980. Have a look at section 41B of the Land Title Act, which deals with the meaning of indefeasible title for common property. What do we mean by common property? What's that? What's that? Can anyone tell me? Units, yes, but body corporate. Yeah, I think that's it. So units, body corporate, strata title, it's that property which is owned in common by a number of people. So that can have indefeasible title as well. Okay, so when you're doing your reading for this week, you need to be clear about the aims. You need to understand what registering an instrument means. That means understanding what we mean by an instrument. So have a look at that, and later tonight, time permitting, I'll draw a distinction between an agreement and an instrument. So you need to understand what this process of registering an instrument means. You need to understand indefeasibility. Hopefully we're getting there. You understand the exceptions to indefeasibility, one of which is fraud. I'm not going to deal with that tonight, but I want you to read that. And you remember the difference between in personam and in rem? Can anyone tell me, has everyone come across that? In personam as opposed to in rem. Can anyone tell me the difference between the two? It's one thing that we'll highlight again in this case that I want to get to this evening. Looking at the answers. Okay, yes, who is speaking? Sorry. I know Monique has put up an answer on the chat facility. All right, so rights against the person rather than in the property. Thank you, Monique. Leonie agrees. I agree as well. So you'll understand, you'll need to consider the difference between in personam and in rem. Okay, so that's one of the things you need to do, and you need to consider other exceptions to the principles of indefeasibility. We'll be talking about this tonight and next week as well. Have a look at your prescribed reading. Make sure you consider the reference reading as well. All right, so tonight we've already talked about what we mean by a certificate of title. Originally, as indicated, we had the original certificate of title in a book called a volume in the titles office, and what we talked about as being the certificate of title that was out in the real world was actually a duplicate original certificate of title, if that makes sense. So the paperless regime, which coincided with coming online, means that now the process has been modified considerably, and in fact I should think that overwhelmingly most titles are paperless. Now I'll look to our conveyances here. to give us some idea of what that means in the real world. What do we mean by paperless title? And I'm looking at Sarah, who can assist us.
Paperless title just means that all of your details are registered electronically as opposed to actually having a physical title. It's been this way for quite a number of years now. There are still plenty of original certificate of titles floating about, which can cause some pretty severe issues when you can't find it and you need to change any sort of details on the title with the titles office. You can get around it, but it's difficult, really difficult.
Excellent. Thank you, Sarah. So if during your reading you come across this concept of paper or paperless title, it is exactly as Sarah described, the difference between simply recording the interest of the registered proprietor on the register, which is electronic, as opposed to having, in addition to that, a physical duplicate original, if you like, in the context of a certificate of title. I hope that makes sense. Have a look at section 42 of the Land Title Act, which deals with the power of the registrar to issue a certificate of title, which is the indefeasible title for a lot. And the registered owner may ask the titles office, the registrar, for a duplicate original certificate of title. So now it's almost the norm that it's paperless, but you can ask for a paper title if you wish. But there is an exception to that. If there's a mortgage on the title, the registrar will not issue the title to you because from a practical perspective, the mortgagees really don't want all these paper titles hanging around that can be lost. So I think politically, when there were changes to the Land Titles Act, the mortgagees, the banks primarily said, look, let's just go paperless. If we have a mortgage, we don't want a paper title. And that's the way it is. And that's reflected in section 42 of the Act. Have a look at part 5 of the Land Title Act. It relates to joint holders in a lot. And you'll see in there the difference between the types of co-ownership in real estate. So and there's a question about section 15, I'll come back to that. But co-ownership, can anyone tell me the two basic types of co-ownership? And while someone's answering that, I'll be looking at section 15. Joint tenants, tenants in common. All right. Nadine, do you want to tell us the difference between the two? Sorry to put you on the spot.
There we go. Sorry. So if a property is purchased as joint tenants, if one of the parties passes away, it automatically transfers to the other person on title. But tenants in common, it can be distributed by a percentage between the people that are involved.
Exactly. Thank you, Nadine. So in a tenancy in common situation, people have, if you like, a discrete interest within the property. They need not have an equal interest with their co-owner, as is the case with joint tenancy. And the law of survivorship does not apply in a tenancy in common. So in a joint tenancy situation, one of the joint tenants passes on. The law of survivorship prescribes that the interest held by that joint tenant, if you like, automatically by operation of law, becomes owned by the other joint tenant. Now, while I've been doing that, Kathleen raised a good point, and that was the effect of section 15 of the Land Title Act in terms of correcting errors. And section 15 does provide that the registrar may correct the register. So I think that looks right. Section 15 allows the registrar to make corrections if satisfied that something on it was incorrect. So thank you, Kathleen, for that contribution. Okay, so let's have a look at then part 6 of the Land Titles Act, which deals with the issue of dealings directly affecting lots. Division 1 deals with transfers, Division 2 with leases, and those of you that are watching this as a recorded session, please dig out your copy of the Land Title Act. Those of you that are watching live, I'm sure you're doing the same thing. Division 3 deals with mortgages, Division 4 with easements, Division 4A, high density development easements. That's 4AA. Division 4A deals with covenants. 4B, profits et prondere, and 4C with carbon abatement interests. Now, if you're looking for some clarification of what we mean by interests within the context of the Land Titles Act, that's a good overview. Now, if you have any questions throughout the unit with deal with interests in land, then you can refer back to those relevant divisions and preferably the sections in your answer. So if you're dealing with a question relating to a lease or a mortgage or a transfer, I would have those relevant divisions handy to refer to in your answer, effectively as part of your answer. It gives you some idea of the basis upon which the registrar is entitled to acknowledge and record the interest of those various things. Part 6A deals with community title schemes. Part 7 deals with other dealings. Now, this is pretty interesting because Division 1 of Part 7 deals with writs of execution, Division 2 deals with caveats, and Division 3 deals with powers of attorney and disabilities. Just a quick word about the third one, powers of attorney and disabilities. The Queensland Civil and Administrative Tribunal has power, which is concurrent with the power in the Supreme Court, to make orders with respect to powers of attorney and disability, dealing with issues to do with capacity, administration and guardianship. So if you have any questions that relate to the operation, effect, validity of powers of attorney, then that goes to the tribunal, which can make orders which can then be reflected in interests on the title. So that's Division 3. Division 1 deals with writs of execution. Does anyone know what a writ of execution is? It's not a death wish. It's not a writ to execute someone. It's something different. What's a writ of execution? Any ideas? All right. It's essentially what occurs as a result of debt recovery, where the interest reflected in a judgment for a debt, a court order, yes, Sarah, is then registered on the title, enabling effectively the bailiff to sell the property as a result of converting that interest into a writ of execution. It's not an interest in the land per se, but it's a mechanism by which the land can be sold to give effect to an order for a debt, a court order. And that leaves me with Division 2, caveats. Have we all heard of caveats? They're very powerful tools, and if you're going to lodge a caveat, do so very carefully and make sure that you have an interest in the land. All right, so firstly, a caveat is something which has the effect of stopping registration of dealings which are inconsistent with or might defeat the caveat or the interest claimed in the caveat. Have a look at Section 124. And Section 124 of the Land Title Act deals with the effect of lodging a caveat. So once the caveat is lodged, then it effectively, this is the term I like to use, freezes the register. Not for everything. There are some things that it won't prevent, but it will otherwise prevent the register. So it's like an injunction in your own pocket. It's a very powerful tool. So we know what an injunction is, don't we? An injunction is where we have an order of the court effectively stopping something from happening. You can create your own injunction by lodging a caveat. It's a really powerful tool because you can say, by lodging this caveat, I now stop everyone from dealing with this title. You have to have good grounds to lodge it, and a caveat can be withdrawn, it can be rejected, or it can be removed. If it's removed by the Supreme Court, and an application can be made by a person affected adversely by a caveat to lodge an application for removal. Have a look at Section 127 which provides that a caveatee, the person to whom the caveat is directed, may at any time apply to the Supreme Court for an order for the removal of the caveat. This is really interesting law. If you actually get involved in this, if you go down to the Supreme Court on an applications day, you might see an application for the removal of a caveat. Now, just to give you an idea of how this works in practice, there is a case that I urge you to look at. It's called Cantrick, C-A-N-T-R-I-C-K, and others, against Thompson and another, 2004 QSC 341. Have a look at the results of the application. And on the applicant's application, the court ordered that the caveat lodged by the first respondent be removed pursuant to section 127, and that the first respondent deliver up possession of the house and land situated at Benoa in that case, and the respondent pay the costs. So it's a really interesting case in that instance, someone lodged a caveat, the person affected by the caveat went to court, got it removed, got an order to boot the respondent out of the house, and the respondent had to pay the costs. Okay, so that's caveats in short. We'll talk about caveats, and if you have a question in an examination that requires you to give advice to a party affected by or claiming an interest in land, you probably want to talk about caveats, but I would like you to acknowledge that caveats are very powerful. They're like your own private injunction, and if you lodge a caveat, be prepared to counter an application by the other party in the Supreme Court for removal of it. And this all happens very quickly. Any questions about caveats or what we've discussed so far?
John, with
Yes.
regards to the caveats, it was my understanding that you could lodge a caveat, but it could either be lapsing or non-lapsing. So with it being lapsing, it means that there's no court order, which means after 3 months, it could be removed unless they go to the court and obtain an order to keep an interest on there. Is that the case, or am I missing something?
All right, so if you say, okay, yeah, you're right. Caveats can be lapsing or non-lapsing. And I'll talk more about how they used to be used in a non-lapsing sense through equitable mortgages a bit later. But you're right, caveats can be lapsing or non-lapsing. Now, your stock standard caveat is lapsing. What that means is that you lodge a caveat claiming whatever interest you're claiming, then it will lapse after 3 months, unless one of two things happen. Either you go to court to support your claim, your interest in the land, by bringing your own application for a declaration, or the other party, the recipient of the caveat, brings an application to remove it. So Cantrick and Thompson is an example of a case where the person who received the caveat made an application to the Supreme Court to say, I don't like this caveat being on my title, I want you to order it be removed, and while we're at it, can I have these orders as well? So that's an example of where the caveatee took action and said, it's lapsing caveat, but I'm not prepared to wait 3 months. I want it removed now. Alternatively, the person who lodged the caveat could go to court and try to support, effectively this is an interim injunction, the caveat, and they say, well, I've got an interest in the land, I want a declaration, and the caveat is there just to stop the register, stop my interest being lost by a sale or a transfer or lease or mortgage, and you pursue it. Now, you're right though, Sarah, in many instances a caveat is lodged, it sits there for 3 months, and then it lapses and nothing much happens. But things can happen. I hope that answers your question, Sarah. Thank you. Now, Siobhan asked a question. Caveats can be part for value in a property settlement for payment of legal bills, or so be really careful here. If you lodge a caveat because you're claiming legal bills, that you may find that the client in that instance will bring an application. And the reason they might bring the application for removal is to say, even if I do owe the bill, how can you claim that by me owing you money, you now have an interest in my land? So you've got to be able to support the application for a caveat or lodging a caveat by saying, I have a caveat because I have an interest in the land. So who would be a person who has an interest in land? Can you give me some examples? Who would even consider lodging a caveat? And Sarah said a lien. Yep, a lien is more, I think, appropriate than a caveat. Okay, so a bank may have an interest in land. Yep, maybe. We used to have caveats on retirement villages to enforce the terms of an option. Yes, all right. So Nadine's come up with Nadine says, look, someone who has an interest in a retirement village with an option to purchase may be able to support a caveat. I agree. Having the option right may be a caveatable interest. Leonie says people owed money. Maybe not. This is where it gets into dangerous territory if it's only a debt. Yes, Leonie?
Coming from the perspective of, say, people that have done renovations on properties, like quite substantial.
All right, so if you're trying to support a claim for a constructive trust, for example.
Yeah, so that sort of, if they've done work on the property and the guy hasn't paid and they're looking to sell the property and they haven't been paid, maybe that.
Maybe, but just be careful. If you're using it for purely debt recovery purposes, caveats can be dangerous. But if you're looking to pursue a claim for a constructive trust, for example, that might be different. Now, we're getting lots of answers here. I'm having trouble keeping up. Greg says, lien, I would believe be applied, wouldn't it? Yeah. Beneficiary, says Tamara. Yes, a beneficiary may be entitled in certain circumstances to lodge a caveat. Mercy says, were the other parties going to sell the house without the other party's knowledge? Adverse possession, says Yomi. Yep, these are possibilities. Person owns property jointly owned until the 2-year period has passed. Yes, Siobhan is sort of introducing the concept of entitlements under de facto property or property law. Another one, of course, is if someone has signed a contract to purchase a property, they would have a beneficial interest in the property sufficient to support a caveat. So that might be another example of where you'd consider lodging a caveat. All right, so do some research on that, but bear in mind that you must be able to support your caveat with the claim that you have an interest in the property. And this comes back to the issue of in personam and in rem. Okay, so thank you for that. Good discussion. What's an alternative? What's a logical alternative to a caveat for a buyer? Might be a softer approach, a more gentle approach. Settlement notice, yes. Do we call them settlement notices, Sarah? No, you're a bit old-fashioned there. Priority notice, yes. I still call them settlement notices. Yep, that's it. So priority notices, where do we find the law that relates to the priority notices? So if you wanted to know the basis upon which you have an entitlement, given that we're Part 7, yes, Part 7 Cap A. It's got its own part. All right, so Part 7A relates to priority notices. And can anyone tell me, I mean, it's all very well to say, oh, these priority notices, but I mean, in practical terms, when does one lodge a priority notice and what's involved in doing so? Again, I'm looking at our conveyances here. Sarah, do you want to volunteer? Have we got any other conveyances? Otherwise, I'll be here. Thanks, Sarah.
Usually it's your bank's requirement. So if you're purchasing a property, they'll usually have a requirement that you lodge a priority notice where it will basically state that their interest is going to be registered against the title, in the event that the transfer occurs.
Good. Yeah, that's fine. So it's mostly, in my experience, for buyers of property to lodge a notice on with the registrar to say, look, just to let you know and let everybody else out there know, signed a contract, expect to have it supported by a mortgage, so this will be coming through. And it has the effect of freezing the title to a limited degree through the priority notice system. And it all comes back to that issue of registration, indefeasibility, being on title. You want to make sure that when you pay the money, you become registered as the owner as soon as possible, and the priority notice just helps to smooth that process so that we don't have instances of competing claims. You see, back in the old days, pre-registration, internet, etc., there was the very real chance that people would have competing interests, unregistered interests out there, and just not on the title. I mean, so there'd be a lot of questions relating to someone having signed a contract on Black Acre and adverse possession and all those sorts of things. I mean, that was pretty, that was sort of common in the old days, but not so much now. I hope that makes sense. All right, so Part 8 relates to instruments. So again, we've got this word instruments, which is really odd word, isn't it? But you need to understand what we mean by instruments and how we deal with them. So look at Part 8 of the Act. It deals with instruments which are capable of registration, amongst other things, and Division 2 deals with what we call standard term documents, which form part of instruments. So rather than lodge a full mortgage, you can refer to a mortgage, which is, if you like, a standard term document. It saves a lot of paper. Part 9 deals with registration and instrument and its effect. Division 1 deals with the registration component. That's sections 173 to 179. This is pretty important, this section, or this part. Division 2, which is sections 180 to 190, deal with the consequences of registration. So, for the purposes of this week's study, Part 9 is critically important. Please read it carefully. So Division 1 is sections 173 to 179. Division 2, 180 to 190. I'll just highlight a few parts. Section 180 deals with the benefits of registration. And interestingly, it says the benefits of the division apply to an instrument whether or not valuable consideration has been given. Remember the first comment that I gave about Lord Watson? Think back to that. Section 181 talks about an interest in a lot being not transferred or created until registration. An instrument does not transfer or create an interest in a lot until it's registered. That's really interesting, isn't it? And I want to talk about equitable interests in the context of that. So when we're talking about Section 181, we're talking about a legal interest not being created until registration. But equity may be able to assist someone who claims an interest in property in relation to something that is not registered. Have a look at Section 71 of the Land Title Act. It works in with Section 181, and Section 71 talks about an unregistered lease is not invalid merely because it's unregistered. Now, that section had no previous counterpart. So Section 71 is interesting in the context of an unregistered lease, and the law now says quite clearly it is not invalid simply because it's not registered. But in the case that I'll demonstrate, if we have time, you'll see that there's a difference between the concept of validity and indefeasibility. Okay. Section 182 talks about the effect of registration on an interest, and Section 183 says a person to whom an interest is to be transferred or created effectively has the right to have the interest registered. Section 184 talks about the quality of registered interests. So do have a look at that, because this is the key part. Sections 184 and 185, I'd like you to read them very carefully, although I'd like you to read this whole part very carefully. Section 184 provides the registered proprietor of an interest holds the interest subject to the registered interests affecting the lot but free from other interests. So that's the key to indefeasibility. And in particular, the registered proprietor is not affected by actual or constructive notice of an unregistered interest affecting the lot and is liable to a proceeding for possession of the land. Don't worry about the next one. Sorry, but the first one is important. So what we're saying is that if you're the registered proprietor, your interest is not affected by actual or constructive notice of an unregistered interest affecting the lot. What does that mean? Can anyone tell me or give me an example? I'm saying it's important, but I want you to read the words and then think about, okay, when might that be effective? Any takers? It's a tough one. You can rely on the register, yes. I think, yes, Siobhan?
Could that be affected if the original purchase was under a fraud?
Yes, I think so. So it would mean that if you had some concerns, then I think that's right. It's not exactly what I had in mind, but I think you're on the right track there.
Is it? I mean, I could be on the same sort of track, but one of the cases it said that it's a fine line between merely knowing about the interest and actually being fraudulent in your actions, like using it to defeat the interest. Oh shit! Anyway, yeah.
No, I think you're on the right track. But look, let's take this scenario, and this is just off the top of my head. So we have a person who becomes the registered proprietor as the registered owner, but immediately before registration becomes aware of the fact that there may be a lease or a lessee having an interest. And they may even become aware that the lessee intends to register their lease, but they haven't got round to it yet. The new owner registers the transfer, becomes the owner, and the lessee says, but I told you that I was going to register my interest before you lodged your transfer, so therefore you've got to honour my lease. Do you understand? So in that instance, they had actual notice of an unregistered interest affecting the lot, but Section 104 says your quality as the registered owner of the property is not affected by that notice of an unregistered interest affecting the lot. You now own the property without having to have regard to that lease. There is always an exception. I'll mention the exception in a moment. It's to do with short-term leases. But if we had, for example, a long-term lease, which is one that's more than 3 years, then too bad. If the tenant hadn't registered their interest, then the new owner's interest in the property is not affected even by actual constructive notice of that unregistered long-term lease. I know that's a lot of words. I hope it makes sense. Siobhan?
Yeah, John, does that apply to residential tenancies as well? Like, for instance, yesterday I saw a property for sale with a residential tenancy in place until March of 2020, which is quite unusual to have one that long. Does that mean that the purchaser has to take on that tenancy?
Yeah, look, so here's the exception, and it's to do with short leases. So under the Act, a lease is a short lease if it's for 3 years or less, and in those circumstances, whilst the lessee will not get the benefit of protecting an option, they will still have the benefit of their entitlement. So that Section 184 does not apply in relation to short-term leases. So I think the tenant in that situation is safe. Siobhan?
Okay, thank you.
And Sarah says, quite rightly, they're covered by the Residential Tenancies Act as well. So thank you for that. Now, Section 185 deals with statutory exceptions to Section 184. So even though we say indefeasibility is great, once you're on the title, you have an indefeasible interest, there are a lot of exceptions, which is the central theme of what we're talking about tonight and next week. So in terms of statutory exceptions, please look at Section 185, get a feel for that, and try to apply it in some realistic sense. Because if you're asked a question about whether someone has an indefeasible title, you must consider Section 185 to see if there's some exception to that issue of indefeasibility. Beyond that, will we be? Or you might be. Good question though. Beyond that, have a look at Section 187, which provides for the Supreme Court to make orders about fraud and competing interests. So if there has been a fraud, the Supreme Court may make an order it considers just, and without limiting subsection 1, the Supreme Court may make orders to cancel or correct an indefeasible title, or create a new indefeasible title, to issue a new instrument, or do anything else. So that in itself, when you read Section 187 and 185, you're almost doing a full backflip and thinking, well, what is the point of saying indefeasible title if it can be defeated? It's not easy to defeat, is probably the general answer. But if someone did want to defeat the title, then they would look initially, I think, at Sections 185 and 187. Now, if they're unsuccessful, they can nevertheless claim compensation. And this is where I think most of the remedy lies for someone who is worthy but defeated because of this concept of indefeasibility. Section 188 applies where a claimant is the victim of, say, a fraud or the incorrect creation of indefeasible title in somebody else's name, or some error or tampering or other loss. In those circumstances, the claimant is entitled to claim compensation from the state for the deprivation. So I think that's the get out of jail free card when considering the integrity of the Torrens title and indefeasibility. Whilst the Supreme Court can correct or cancel indefeasible title, I think it would be loath to do so, particularly in knowledge that under Section 188, it has the power to order compensation be paid. So I think that's the way around it. I hope that makes some sense. Now, tonight we've talked about registered and unregistered interests. You've been very patient. You're hanging in there well. I will touch on just a few cases now. We need to understand the distinction between something which is registered and something that is unregistered. Now, I guess that's pretty simple. It's an instrument, it's either registered or it's not. But if it's not registered, there are two types of interests that someone might have. The first is that they may have an interest in an instrument that is capable of being registered, but for some reason it's not been registered. So their interest is as an unregistered buyer holding a transfer in their favour, or an unregistered mortgagee holding a mortgage signed in their favour, or an unregistered lessee, for example. So that's one way in which you might claim to be have an unregistered interest. The other is that you may claim an unregistered interest such as under something which is not capable of registration. And I think we mentioned it before, I forget who mentioned it, but as a beneficiary under a trust, for example. That would be an example where you have an unregistered interest in land, even though what you have is not capable of registration. So you've got those two broad categories. Now, a court may recognise the equitable interest in land either way. So what is necessary then to create an equitable interest under the Torrens system? So the categorisation can be important. Here's an early case. It's one called Barry against Hyder, Heider, 1914-19 CLR 197. In that case, the High Court confirmed that unregistered interests may create equitable interests. So if you remember what I mentioned at the start of tonight, that there's this distinction between at law and in equity. So if you become registered on the title with your instrument actually registered, you become the legal owner. You have an interest at law. While you've got it in your hands, capable of registration but not registered, you don't have a legal interest as such. But Barry and Hyder would be authority for the proposition that you have an equitable interest. I know it gets a bit tricky. Now that principle was confirmed more recently in a case of Chan against Cresden, Pty Ltd, which is 1989 168 CLR at 242. Now in that case, the High Court concluded that the statutory provision, which was at the time section 43 of the old Real Property Act of 1861, which provided no instrument shall be effectual to pass on an estate until registered, meant that the effect of the provision is the unregistered instrument is ineffective to create a legal or equitable interest before registration, but it does not void the contract or make it inoperative. Now, because it's not void, the agreement may be enforceable in equity, which means that it creates an equitable interest. So what do we take from all of that? I know it's subtle, but there is a distinction I want to draw here. And the distinction is this. The unregistered instrument may be ineffective before registration, but the agreement contained within it may be enforceable in equity, and through the agreement, rather than the instrument, the holder has an equitable interest. You're doing well if you can follow me here. I know this is a bit tough. This is the toughest part of what we're doing tonight. What I'm drawing to your attention is this, that even though the Land Title Act will say something like this is ineffective until it's registered, that's the legal position, and that's dealing with the instrument side of what you're dealing with, as opposed to the agreement side of what you're dealing with, which may be enforceable through equity, and you may have an equitable interest.
So, John, sorry, so is that basically saying that if somebody doesn't have a registered interest, they can still go, oh, well, the instrument says, the instrument isn't registered, but our agreement sort of says that I have a registered interest?
Well, not a registered, you're very close.
Yeah.
I think you have an equitable interest.
Yeah.
Okay, so perhaps an example of that might be a lease. So when we have a lease, let's say for 5 years, what have we got? We have both an instrument capable of registration and we have an agreement. So in terms of it being an instrument and being 5 years, so it's not short term, it's not enforceable at law until it's registered. However, if we have that same agreement unregistered, it's still an agreement, it's still a contract, and therefore the holder of that may claim an equitable interest. I know it's subtle, but there is that difference. Now, Section 43, which was the basis upon which Chan and Cresden was decided, was replaced by Section 181 of the Land Title Act. So have a look at Section 181. The new section was slightly different. And it was slightly different in this sense that the new section said an instrument does not transfer or create an interest in a lot at law until registered. which brings me to the case I wanted you to have a look at. It's called, and I promise we're almost finished, this is Ashton and others against Hunt, and it's 1998 QCA 308. It's a pretty straightforward case in a way, but I think it's good because it ties in a few concepts that we've been discussing tonight. So firstly, this case was about a lease, and it was where the landlord sought to pursue a debt under a lease guarantee. And it was an unregistered 5-year lease. Now, if you've got a 5-year lease, please register it, and it'll save all these problems. If it was registered, we wouldn't have had an issue. But for some reason, it was unregistered. I don't know why these things happen. But the question was the extent to which there were interests pursued that could be pursued in that document. So if you look at the decision of Justice Thomas, read paragraphs 13, 14, and 13 through to 16 inclusive. And that's pretty much all you need to do for Justice Thomas. Paraphrasing said, the combined effect of section 71 and 181 of the Land Title Act seem to be that an unregistered instrument fails to transfer an interest at law, but that doesn't render it invalid because of the lack of registration. So what does all that mean? And it means that there is some limited effect to be recognised in the document. It's not totally ineffective. It remains the source of equitable rights, and therefore it can still be pursued to some degree, but it's limited. And that in paragraph 16, His Honour said, but that doesn't, section 71 falls short of declaring that the unregistered lease is valid for all purposes between the parties. So in those 4 paragraphs, His Honour is saying, look, it's not effective at law, but it's still effective to some degree. Section 71 doesn't take us all the way, so you've still got to register the document, but it's still got some use. Have a look also at paragraphs 14 and 22 of Justice Ambrose's reasons, where in a different way His Honour describes the legal position. If you can read those paragraphs in that case and understand it, I think you're pretty close. But don't worry, it is tough, and don't worry too much if it's really difficult for you. So what I'll finish up on this. The conclusions we can take from that case are that it is important to register a registrable document. We know that. It doesn't disturb the law created in Chan against Cresden, which was authority for the proposition that a lessee fails. If a lease fails to satisfy the formal requirements, it may nevertheless have an equitable value to it. And also bear in mind section 185 1B, which talks about short-term leases. Okay, just to wrap up, part 10 relates to liens. A few people have mentioned liens tonight, L-I-E-N-S. It's a funny word, liens. But a lien is, if you like, the right to hold on to something until you receive payment. Part 11 deals with miscellaneous matters, and just to the final thing, equitable mortgages. Section 122 of the Land Title Act basically says that it's no longer possible to lodge a non-lapsing caveat to create an equitable mortgage. I think that was something that you raised earlier, Sarah. Okay, that's it. I promise that's it now. We're done. So thank you for your patience and your good work tonight. I know it's a bit confusing, but please read those sections, a couple of cases, and we'll see you next week. All the best. Bye then.